Hello, everyone. Good evening. Carl Steinbeck here. Sunday night. Just wanted to cover a couple of things that I think a lot of people have apprehension and a lot of nerves on edge, just with regard to the way we see this prosecutor that's putting such a spin on everything that he's representing to the court, and the judge taking these just absolutely ridiculous, constitution destroying motions to exclude this and that by the prosecution. The judge is pretty much, for the most part, entertaining all of them and denying the defense to present their case, their defense, which is guaranteed by the Constitution. So these are constitutional magnitude errors. And I think the prosecution, from what I can tell, all my many years of doing trials in various jurisdictions, various states, forums, I can tell you that my perception is that it's all about the win. It's all about the win, especially if you're hired just for one case. It's all about the win, and you can lose sight and focus on what justice is about. And you're expecting some kind of payback in the end. It's just not about making money. And it's very odd that a defense practitioner would leave their private practice to go in and take one case that's going to be wrapped up in less than a year, and then have to go back to your private practice and almost start over, because criminal cases move pretty quick. So you pretty much have to shut down your practice and start over. So there's some other things I suspect are going on here with regard to why this prosecutor would take on this case. And then you look at it from the judge's perspective. This judge, in her rulings, as a former chief public defender for her latter years, and she was a public defender, from what I'm told, and seen her entire career before she became a judge in 2009. And so she's been on the bench long enough to know how to see things and call balls and strikes and have this appearance of fairness. And what we're not seeing is any sense of fairness and due process for Karen Reed's team in the first trial. And we're certainly not seeing it now in the second trial prelude here, as we're getting ready to have the evidence come before us here. And because jury selection is going so fast, we may even have the first witnesses as soon as next week, next Monday, perhaps. So, or perhaps even sooner. Things are moving really fast. That's just a sign also, though, that the judges has so much control over this process of interviewing witnesses. I think if you had the defense able to probe the prospective jurors and also the prosecution, you would have this being a much longer process, but it's really being shortened. And as I've said before, this is going to hurt the process in the end, because it's more likely to get a hung jury, because you don't really get good screening of jurors and eliminate biases and prejudices and just outlier people that got really strange ideas on things. So yeah, the fact that it's moving so rapid, fast, the judges wants this case over with. I don't even know if the speed is a factor, but it seems like it perhaps is, for why she's denying the defense so much an opportunity to defend Karen. And they're really cut off the knees. They got their hands tied behind their backs. Their eyes are blindfolded, and almost like they got their duct tape wrapped around their ears and mouth as well. I mean, that's basically the kind of defense lawyer they want in this case. But thankfully, we do have a constitution here in America. It's not alive there in Massachusetts and Denham Court with this particular judge. But keep in mind, there is an appeal process. If it comes to that, I don't expect that to be the case. But if it comes to that, with all the denial of evidence and experts at that, I think with all the objections and the tone and demeanor this judge has for the defense, that's it telegraphs to the jury that Karen's guilty. Don't waste your time. Just get straight to it. So I think that the thing that I'm taking some solace in is, if things could go bad, then and there's some type of conviction, it's not going to be, first of all, for second-degree murder. I think there's nothing about Karen's behavior that any reasonable juror could conclude. I become really good at predicting jury outcomes in my 30 to going on 35 years almost. And I can tell you that there's nothing about this case that I see second-degree murder charges sticking. I think it's an absolute abuse of discretion. It's an intimidation game. They're trying to use that second-degree murder charge to strong arm Karen into pleading guilty to a lesser included offense. I think they surely would deal with this on a manslaughter level, given the shaky evidence, which they know is shaky, and just a bunch of flim flam hogwash they're trying to stick in and really trick the jury into believing this stuff is a genuine second degree murder case. So I think the jury is never going to buy that whatsoever. I think just like you saw in the last case, the jury was very confused, not sophisticated enough to really understand what was going on with the witnesses. And we haven't heard from all the jurors either. I don't equate to what one juror says to all 12 necessarily. So it did appear that the foreman of the jury had some law enforcement background, spent 20 years, I think I heard, was a 20-year veteran of the police department who became a medical provider. And that's just somebody you don't want to have on there. So I would hope that the defense learned their lesson from the first trial, that you don't have anybody with any ties to law enforcement, let alone served as a law enforcement officer for many years, because the blue is going to back the blue on most cases, except where you have honorable people like the Canton detective there that I had coverage on last night, Sergeant Peter Murphy, as well as we've seen the Carolina Highway Patrolman who's been a guest on my show the last 2 times, that talks about the trampling of the Constitution, all the prejudices and biases and botched procedures and protocols done on this case by the prosecution. So anyway, I do think that the saving grace for this thing is going to be, keep in mind there is a Constitution still in play. We don't see it in this courtroom much at all, and despite these horrendous efforts of the prosecution to deny the evidence for the defense from coming out and putting a spin on facts and his motions and stuff like that, I think it's going to be probably the worst type of prosecution I will ever see in my lifetime. And but in the end, I think that the jurors are going to get it, even despite the judge's ruling denying a lot of stuff from coming in, like she did in the first trial, and showing that overt bias by the way she rules on evidence. So, in any event, I wanted to show you case law here. Just 2 cases I wanted to cite before you walk through them here, to show you that there is some history of cases you can find appellate decisions on. This is a Massachusetts appellate court decision from 1997, Commonwealth versus Richard Steinmeier. And in this particular one, the defendant was convicted on charges of assault and battery and some other stuff. And they claimed on appeal that the trial court had committed error that was deprivation of constitutional rights, because they prevented a expert from coming on board here. So actually, it wasn't even an expert. I take that back. It was I can move up here. The judge actually struck the testimony of another witness that provided corroboration for the defendant, and the witness's name was Eric Van. And part of the thing was the defense counsel had failed to comply with reciprocal discovery, the same thing that Brennan's arguing here. So let me see here. How do I get rid of this slide 2 showing up where I'm trying to read it? I can't scroll it. So anyway, the judge, after the jury heard of this testimony from this Eric Van, the judge then decided to strike the testimony, instructed the jury, disregard this testimony from this witness, and she determined that was a proper remedy. So in other words, the defendant got hurt. This Steinmeier got hurt by the representation of the lawyer, or lack of it, to comply with discovery. Sort of like what Brennan's trying to do. He's arguing the ARCA witnesses, and there's been violations of Rule 14, and so he's trying to get the judge to get these ARCA witnesses struck, and so there's a case that's very similar to that kind of thing, except this is not even an expert witness; it's just a witness that sort of provided some background support for what the claims of the defendant were. So, and here the judge said in the highlight in yellow at the top there, it says, "I think the only remedy available is to strike the testimony of Mr. Van, and I will instruct the jury to do that." And then the defense counsel placed on the record his contention that there was no deception on his part and that the statement in question was sitting quite openly at the counsel's table. And he indicated that he informed the prosecutor before the trial, even that the content of Mr. Van's testimony, that he would testify with regard to the telephone call and some other stuff. I won't get into the details of this case, but he stated that his mistake was inadvertent, a claim supported by a fair reading of his other statements, revealing his misunderstanding of the nature of the writing in question, his obligations with respect to it. And then, anyway, the judge decided to make this drastic remedy to solve this apparent reciprocal discovery violation. So this is what this went up to appeals to this holding of the court, that the defendant's constitutional right, and they're citing a Chappie case, which I will cover also as well after this one case. This one here is a constitutional right to defend itself against a criminal charge entitles him to call witnesses testify on his behalf. And I've talked about that before. That's Sixth Amendment right. It's also applicable through the 14th Amendment, which applies to the states. So the Sixth Amendment right, I'll just say generically, is what it entails. It's part of also the due process for just a fundamental right to have a fair trial. And so what the prosecution is trying to do here, and what the judge is depriving Karen Reed of, is a fair trial. There's no doubt about it, in my opinion. And I think that they have to know they're doing that too. I think that they for some reason just don't want to rule favorably for her, give her the rights to have a fair trial. I think they must realize what a weak case it is, and why they want to get a conviction on Karen Reed. I don't know what she's done to tick so many people off there in the DA's office, Morrissey and this judge, but it definitely looks personal. I don't think any reasonable based prosecution office would try this as a second-degree murder case at all. Even on the manslaughter with the ARCA witnesses, it's pretty much dead in the water. And so the court is citing some other cases here. It says, however, the right to call witnesses is not absolute. In the face of legitimate demands of the adversarial system, this right may be tempered according to discretion of the trial judge. They cite another Commonwealth case that does cite a U.S. Supreme Court case. And it says here, given that the pretrial conference report filed pursuant to another rule of procedure, and they're citing a Massachusetts case from 1979. It says, is a device designed to respond to legitimate demands of the adversarial system, and the complained failure of the defense counsel to provide reciprocal discovery to require the judge to balance the Commonwealth's interest in enforcing its procedural rules against the defendant's constitutional right to present evidence in his behalf. And then it goes on to cite the judge is charged with significant discretion, and her findings generally should not be displaced absent appellate proceedings. And then it goes on, while we commend the judge for her interest in promoting truly reciprocal obligation on the part of a criminal trial attorneys, we think that on this record, the sanction imposed was too severe and unnecessary, invasive of the defendant's right to defend himself. So this is just a corroboration type witness of a telephone call that was relevant to this witness, this defendant defending himself. And so this court here is seeing that this is really a drastic remedy. You're going to deny somebody really they're a key witness that's going to make the difference between a conviction or not, the actions of the attorney. And then it goes on to say that in imposing the severest sanction, that of preclusion or striking of evidence, and it cites a U.S. Supreme Court case, Taylor versus Illinois from 1988, And then talks about how the judge should make clear there's certain factors that need to be balanced to make a vindication of the rules that exist. And these factors include prevention of a surprise, evidence in bad faith in violation, prejudice to either party, effectiveness of less severe sanctions, and the materiality of the testimony to the outcome of the case. Here, that is huge. When you think of the exclusion of the retired FBI agent Easter, I mean, this is so significant of a sanction to say basically, he's not coming in, and this is not an issue that we have to be concerned about because the lay persons know this. So he's not. He's not being kept out for this reason, that there's a discovery violation. But this will apply to the ARCA witnesses. So I think it's going down those tracks already from what I've heard in arguments. And the judge is going to. I'm leery about the fact that she realized if she opens that door and kicks these ARCA witnesses out of the courtroom, and they cannot testify because of some ticky-tacky discovery rule reciprocal violation, this is like very, very much going to get busted on appeal if there's any kind of conviction. So I think it's an absolute abuse of discretion, and that would be so severe. This is like these ARCA witnesses can make and break the case for the defense. So in this one, the court then went on to say that striking the testimony already heard by the jurors, even though they had heard it, they were told to disregard it, and it was neither justified nor harmless beyond a reasonable doubt. Harmless beyond a reasonable doubt is a standard of review if there's abuse of discretion by the judge. So in this particular case, this is a Massachusetts case that reversed the decision of the trial court judge. And the reason being, there's abuse of discretion because this actually prevented the defendant from having a fair trial and presenting evidence in his defense. Next, I'm going to look at all right, that's the other wrong one. Hold on a second here. Stand by 1 second. That window is not open like I thought it was. It was a second ago. This other one I want to show is a federal case. Chappie. This one here. No, where'd it go? Stand by. It somehow. Almost there. All right, this one here, it's not allowing me to scroll for some reason. Here we go. All right, this one is a district court from Massachusetts. It's a 1987, so it was before the previous case I just covered. And this is in district court. So this was a case. This Douglas Chappie was the defendant. He got prosecuted. And after an appeal process through the state court of Massachusetts, he then filed a petition for habeas in federal court. So a federal district judge, a trial judge, not an appellate judge, got to hear it. Sort of like we saw in Karen Reed's case. It first went to a district judge, then went to the Court of Appeals, first district, and now there's a writ for cert petition before the Supreme Court. So this is one that's just still at the trial level for the federal court system. And it is actually a case there in Boston. So as I said, writ of habeas corpus. In this particular one, defendant was charged with trafficking cocaine, and he was obviously convicted. Otherwise, you wouldn't have a decision like this. So he was convicted. If he would have won at the trial court level, there is no decision to appeal. The government cannot appeal a defense win. So it says here, this petition raised the question of whether and under what circumstance a trial court may exclude defense witnesses from a criminal proceeding because the defense counsel intentionally refrained from giving the prosecution timely notice of witnesses' names and addresses. So that's a pretty big deal here. So then they talk about the Sixth Amendment and the 14th Amendment protect the criminal defendant's right to call witness on their behalf. And exclusion of defense witnesses threatens that right. And that's citing some Supreme Court case law here, Chambers v. Mississippi and Washington v. Texas. Those are well-known cases for criminal defense practitioners as well as prosecutors. It does cite then in this judge's opinion that it's not absolute, Sixth Amendment rights not absolute, but under circumstances must give way to the legitimate demands of the adversarial systems. That basically has to do with like discovery type compliance and any other type of remedy the court thinks is appropriate for handling the way the attorneys are conducting themselves. And it again talks about the Supreme Court has upheld against due process and self-incrimination challenges state discovery rules that require a defendant to give prior notice of an alibi witness, at least where the defendant receives reciprocal discovery rights. So Karen Reed has a reciprocal discovery in place here for this trial, like she did the first time for trial one. And it goes on to say the Supreme Court has expressly reserved, however, the question whether it's constitutional under the Sixth Amendment to enforce these discovery rules by imposing a preclusion order against a criminal defendant. So basically, they're saying this the same kind of thing with ARCA witnesses. Is that really a remedy you want to fashion, Judge, if there's a discovery violation? So without going through standard of review, here it talks about the court balances different factors, determine whether to exclude witnesses. First, the Superior Court supposedly found that the defense counsel acted in bad faith and it created unfair prejudice that disadvantaged the Commonwealth because they had 3 expert witnesses and not a single one of them was given notice of to comply with the timeline. Here, the ARCA witnesses, they've known about him. In fact, they knew about him the exact same time that the defense knew about him when that was turned over by the U.S. Attorney's Office. So that 3,000 plus page investigation report. Second factor is materiality of the evidence excluded the trial. The judge made no explicit finding here. I mean, the ARCA witnesses are as critical as it gets. And I would say even this Easter witness, this FBI agent Easter, he's a critical witness for the defense. The judge has already denied it. And it goes on to say, while admittedly the defendant has the opportunity to cross-examine the government's expert on the same issue, the right to present one's own defense is greater than merely the right to cross-examine the government's witnesses. So this is something I think Judge Cannone in her ruling excluding this FBI agent Easter, she's basically saying the jury can understand police procedures and the jury doesn't need any assistant to help them understand those police procedures, and prosecution can do cross-examination. Well, what if the witnesses don't admit it? What if these cops and investigators don't admit that they botched the evidence and everything was wrong? I mean, we already saw that being poo-pooed by this Five Stones report. They didn't seem to have much of an issue of any of these investigation procedures being a big deal. I mean, they cited some things they failed to follow, but they never talked about the magnitude and the grave, serious concerns this poses for undermining a fair trial for the defendant. None of that was touched on. And here they said it's entirely possible the testimony, meaning these expert witnesses that they tried to spring on the prosecution in the 11th hour, it's entirely possible their testimony would have created a reasonable doubt as to whether the substance seized was a controlled substance within the meaning of statute. So what this defense counsel was trying to do was have some experts talk about how the controlled substance could have had some different chemical makeup or it didn't exactly fit within the federal statute to make it a crime of that magnitude. So that's a critical thing. And just being able to cross-examine somebody on this is not the same thing as having an expert to say, look, here's the problems that labs have in determining what that type of substance it is, what its true weight is, because the more the weight there is between this illegal substance, the higher the level felony it is, and the more your sentence will be. So that's why this is a critical issue here. And then they cite the Washington case we talked about earlier. It says the right to offer testimony, witnesses, and compel their attendance if necessary is in the plain terms of the right to present a defense, the right to present the defendant's version of the facts, as well as the prosecution's to the jury so it may decide where the truth lies. Just as the accused has the right to confront the prosecution's witnesses for the purpose of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is a fundamental element of due process of law. Imagine that. And Judge Cannone is saying, no, you don't need Easter. You don't need Easter. And she may be saying the same thing about these ARCA witnesses. She's just wanting so much to kick these ARCA witnesses out and to punish Karen in the process. Even if her attorneys did something wrong, that is not the remedy you make. You don't punish the defendant if the attorneys for her did not comply with all the discovery rules. That is such a nuclear weapon against the defendant, and it's just going to create a reversible error. So, but I think they don't care. It's conviction at any and all costs at this point. And this federal judge here wrote, in addition, there's no indication that the testimony of the defendant's experts was to be cumulative. All right, so there's no cumulative expert testimony here that's being offered that I've seen so far that's being offered by the Karen Reed defense team. You got Easter. He's the one and only one for law enforcement. You got the two from ARCA. Those two are not covering the exact same issue. They each had their own subset specialty. So there's no cumulative. Cumulative means it's overkill. There's too many people saying the exact same thing. It's just not efficient use of the government or the court's time to be bogged down with the witness after witness after witness saying the same thing. So, and it says here, in fact, the defense counsel specifically argued that his witnesses would contradict certain statements by the government's experts. That's exactly what we have for Easter. That's exactly what we have for the ARCA witnesses. In such circumstances, cross-examination, however searching and skillful, is not and cannot be the functional equivalent of the presentation of affirmative evidence. So that's what we have here is this judge is trying to say cross-examination is the same functional equivalent as calling an expert witness. Can you imagine that? I mean, this is so absolutely ridiculous. There's no court of appeals that's even going to take this judge serious with her type of rulings like this. And the third and fourth factors are the extent to which the prosecution was surprised and prejudiced and the effectiveness of alternative sanctions. While the government clearly was surprised, it would have had some prejudice to the government had the trial court allowed the testimony of experts, witnesses to be received at once. It is not all clear that alternative sanctions could not have minimized the prejudice. And it goes on to cite a Fendler case, another Ninth Circuit case. So that's in the western part of the United States, the Pacific Coast region. There they cite the court where it said that there's every reason to believe that a preclusion order is no more effective than any other available sanctions. Indeed, stiff disciplinary sanctions against the offending defense attorney seems more effective deterrent. So sanction the attorney for contempt of court or something like that. If the attorney botched something and the client's going to be hurt by it if it's kept out. So don't punish the client, don't punish the defendant. And it said here the court concluded that given the availability of such alternative means of forcing compliance with the discovery orders, it would seem that preclusion orders are seldom, if ever, truly necessary. I totally agree with this. You don't need to punish the defendant because then you run the issue of ineffective. So if the defense attorney does something that creates a preclusion order of that expert witness or that critical witness from being called by the defense, that attorney is basically ineffective. And you have a constitutional right to competent counsel that are effective. And if they are, in essence, ineffective, then guess what? That means the case will get busted on appeal for that constitutional ground. So if it's not one constitutional ground because you violated the Sixth Amendment, so Judge Cannone is violating the Sixth Amendment if she tries to keep out the ARCA witnesses because of something that Jackson and the team failed to do properly, then um, if that evidence is kept out, the ARCA witnesses are kept out, and I think that she's really gunning for that, like I say. So if she keeps out these ARCA witnesses, guess what? Then that's ineffective assistance. So the appellate lawyers are going to say, guess what? The Jackson team, what they wound up doing was, not complying with Rule 14, and it wound up being something that they should have known better. It was not comporting with standards of competent counsel, and therefore creates an issue that precluded the magnitude of these witnesses that were pretty much shut down the whole government's case on a number of levels, and that is not being presented because of the errors and omissions of the defense attorney at the trial level. So guess what? That sounds like a really good ineffective assistance of counsel claim. So this thing is set up, like I say, on a couple prongs of being reversed on appeal. If there is an appeal, like I say, I don't think that she's going to get convicted. But if she is, I'm just trying to tell you guys some of this law that's going to kick in that so far has not been considered by the courts there. And it said here in the present case, the defense counsel is willing to agree to a continuance, allow the government to interview the expert witnesses, call other chemists in rebuttal that would mean, and to recall the Commonwealth's own chemist. So the judge can fashion any kind of remedy that's not going to hurt the defendant. It's just going to avoid the element of surprise for the government, because that's what their main gripe was. Hey, this is a trial by ambush. We don't have to, be unprepared to how to cross-examine this witness. So the judge could have crafted a remedy. Said, okay, this was a trial where it could have easily been remedied. These three chemists would have been available to testify all in one day. 2 days later, after the prosecution could have done their homework on the case. So there's no reason to punish the defendant. And it says here the record did not indicate that the trial justice considered the effectiveness of these alternatives. In fact, the judge responded to defense counsel's suggestions by pointing out that the prosecution had been had, quote unquote, and that the witnesses would therefore be excluded. Thus, his refusal to impose less severe sanctions was not based on their effectiveness, but on the egregiousness of the violation. So it's more or less to punish the attorneys, you're going to punish the client. That's what this federal judge is saying. Finally, the Superior Court did not find, and there's nothing in the record suggesting there was any complicity between Chaffee and the defense counsel, absent evidence of complicity, because that's one of the prongs they can look at is like, how much was the defendant being part of the problem here? And absence evidence of complicity, it's unreasonable to deprive a defendant of his right to present a defense, a right guaranteed to him or her, in this case for Karen, by the Constitution, even if his attorney intentionally failed to provide a timely list of defense witness to the prosecution as required by the Commonwealth's rules of civil criminal procedure. So I'm just saying here, from this case, I can assure you that if Judge Cannone keeps out these ARCA witnesses, she's going to get busted on appeal just like this one. And she's also going to get it's a reversible error. This case will never stand scrutiny on any appeal if there's any conviction for keeping out the Easter witness as well. Then there's some appellate procedure language here I don't need to get into. It said here they looked at, this was since this court has held that substantial constitutional rights have been denied by the refusal to accord a hearing to Chappie's affirmative evidence, and must determine if this error was harmless beyond reasonable doubt. So if the judge already by keeping out Agent Easter, and then if she does anything about the ARCA witnesses, keeping them out, it cannot be said that the exclusion of the expert witnesses was harmless beyond reasonable doubt. It's going to be the same kind of review on appeal. The witnesses here constitute Chappie's entire defense, and if credible, could have created a reasonable doubt as to the nature of the substance C. In this case, I would say the Easter is not the entire defense, but that's not going to matter in this case. It's a critical thing given the numerous errors that the state and the Canton Police Department made in their so-called investigation, and denying also, if they deny the ARCA witnesses, the ARCA witnesses have the kind of expertise that the government's not had to date. And I understand they're going to bring somebody else as a counterweight to that, but we'll see what kind of background they got. I can't imagine that they're gonna have anything that's going to be able to match the ARCA witnesses. And here again, do you see what I was talking about earlier? Chappie also raised the ineffective assistance of counsel claim in light of the court's holding it's unnecessary to address that claim. So like I say, if the judge tries to say here, Judge Cannone says that the ARCA witnesses must be included because Jackson and the defense team failed to comply with stuff that they should have, weeks prior, months prior, then you're looking at ineffective here. So it's just something that judges, if they have their understanding of what due process is, they don't want to go down this road and allow this to happen. But not here in this court. They're just willing to go for broke. And it almost seems like they know that the only way she can get a conviction is if they hide the truth, deny experts. And how do you do that? Through things like reciprocal discovery issues and technical stuff like that. So technicalities or ridiculous arguments like cross examination of the government's experts is just as effective as the presentation of your own expert that rebuts them. So I think if I was the defense, I would have Easter on the standby, have him still be up there and call him as a rebuttal witness. So you have a right to rebut the prosecution's evidence. So let's see if they call him as a rebuttal evidence and cite the cases that show this is reversible error for the judge to keep this kind of evidence out. I would just still keep fighting it. I wouldn't tolerate this absolute travesty of a fair trial. All right, with that, that's my comments for tonight. If you have questions, I'm going to do Q&A now. If you have questions, go ahead and do red emojis if you can, just so I can distinguish that from commentary. Keep it clean. I've had some trolls lately show up that are just an absolute disgrace. So just keep it professional, and you don't have to get your comments stricken. Thanks, 60 Insane. It's thanks, aka the cat lady. Is Sir rebuttal an option? There can always be a chance for rebuttal and Sir rebuttal, and depending what they open the door to. It's not always a guarantee, but it's a possibility. Eliza is saying, I think Cannone is scared of Arcus too. Yeah, I mean, she knows that she just blows away Trooper Paul. It's no comparison. Debbie Pelham is saying, this is crazy how much the Commonwealth's get away with. Cannone's embarrassment to the robe, just another endless hurdle the defense has to overcome because Brennan has no case. Yeah, that's the way I look at this as well. They just don't have a case. All right, somebody dreaming that Karen had a not guilty verdict. That's nice. See, I just can't imagine. Could jurors up there in Massachusetts be that clueless that they could convict her of this kind of sham evidence for the prosecution? Leslie, you're asking, do you think Karen Reed can stay out on bond pending appeal if convicted? She has some serious medical conditions. Yeah, I think she'll be able to stay out on bond. They're not going to revoke it unless she does something that would be in violation of the terms and conditions. She should be fine. They're not going to up the bond or revoke her bond and say she has no ability to post bond unless she would do something that would be indicate she's a flight risk or some other type of crime. Anthony from Ohio, you're saying Commonwealth can't handle ARC witnesses. They're scared of them. I think that's a true statement. I think they definitely are scared of them. They're not gonna have anybody with that kind of firepower coming in. Tammy's asking, why would a judge ever risk reversal or her judicial reputation like this? I can't explain it other than the fact that some kind of loyalties, they're either past, present, or future, or a combination. It makes no sense. I've never seen something that ridiculous. Keeping out Easter. I have in a case, but it was right. Mickey, thank you. You're asking, why is the defense filing every day for jury names, jury number, and information? Keep in mind the prosecution. I haven't heard the latest. Prosecution was trying to do criminal background checks on all these jurors, so it's really a shocking thing to have that much. The prosecution is trying to weed out people that may have had any kind of involvement with law enforcement, and by that, they're going to try to kick them off the jury and say that they're biased and prejudiced against law enforcement. That's just really something that I've never seen before. It just shows how desperate they really are to get a conviction. It's not about the fairness of it. Chloe's mom, you're asking, do I think the jury selection is going too fast and the attorneys don't have a chance to talk to them? I think it's so limited in what they can say that it's nothing that leaves me feeling comfortable about what kind of jury is going to be seated. Kate, you're saying, but all of Brennan's discovery not coming in on time is okay, and that's infuriating. Yeah, this stuff has been trickling in trial one, and that's okay for trial two as well. There's no harm the prosecution can ever do that gets the judge's ire. Lisa Burton, you're asking, why are they not getting that judge replaced? Unless they can get have some kind of conflict, the judge agrees she's conflicted by, she's going to stay on this case. And other judges on the higher level, they sort of stay out of it. Swampy saying, look, judge gets a guilty verdict for the team. She's done her job. She gets overturned on appeal. She doesn't care. She did the best she could do. And so, yeah, I don't understand why you'd want to get reversed on appeal, other than you just really just lost your focus on what the law requires. Andy School saying, are you concerned about jurors already placed by The judge essentially 10 already. Yeah, didn't have any for Friday though. I think did they go a half a day Friday? So it may take a full week to get the other 9 in place. This is going to be a long trial. It's going to be really painful to watch. Seeing the prosecution and the judge, it's going to be really painful to watch. I'm not looking forward to that. It's gonna really be hard to see such a railroad job going on. Clayton John is asking, do I think a jury of 12 jurors will be more knowledgeable than an ARCA expert? I think that depends what you're talking about. If you're talking about the specifics of what the ARCA witnesses testified to, then, I don't think any of us have that kind of expertise. As a matter of generalized knowledge of the ways of the world, I think a jury of 12 is the best you want to have. I think the more people you have that have to have uniformity, unanimous verdict is better to help the defendant have a fair shake. Because if it's just 2 witnesses getting to agree, that's a lot easier standard. Psychologically, it's much easier to get 2 people agreed on something than it is 12, right? So in this particular case, 12 people, assuming they screen out people that have like I've said, some kind of prejudice or bias against Karen, then assuming they get rid of those kind of people fairly enough and they're being honest, I think that what you have in this particular case that's different from a normal one is you have so much publicity on it that you may have a lot of jurors not wanting to tell the truth on what they really have come up with in terms of whether they have fixed a formed opinion on it. And that can go one way or the other. You could have people that think Karen Reed's totally guilty. They're not going to admit that in court because they want to sit on the jury and they want to get her convicted. You also have some free Karen Reed people on the jury that don't reveal that, and then they wind up sitting on there. And but I think there's more likely to be jurors that are in supportive of Karen that are from that community than are against her. So I think she's got that going for her. And I think there's going to be a lot of jurors that are going to social media, even though they're not supposed to. I think there's going to be a lot of jurors going to social media to find out exactly what's going on behind the scenes. So I think that plays into Karen's favor. Rage of Dragons saying the good news is that she has a ton of grounds for appeal, a veritable laundry list. Yeah, that's what I feel good about as well. Anna Jaski's asking, do I think the defense will have a fair shake at cross-examination? I don't. I think this judge doesn't want to have a real rigorous cross-examination anytime by this defense team. So it's going to be tough to watch. It looks like she does what she can to protect witnesses. Look at what she did with Higgins when he's up in the stand. She called his attorney up there, and he's like, "What am I supposed to do?" So very just strange actions by this judge. Continually strange behavior. Like she's pulling for one side. Eliza Krogan, you're saying a courtroom visual is important with juries. This set up bad with O'Keefe staring down defense and Karen. You're talking about John O'Keefe's brother Paul. Yeah, him, the way he's sitting there like that, he's got a real angry look and staring down the defense. Yeah, that's not a good thing. If I was a defense counsel, I'd object to his seating there. Monty's live. Thank you. You're asking, did anyone else hear Karen say he lived on Meadow in a call with Sergeant Good? It really sounded like she used past tense, lived, not lives. Was that just me, or did she actually say that? I don't recall that. Sorry If anybody can jump in and help out. Ilo shows does Judge Cannone have too much power with jury selection? I think she's yielding way too much influence in that. And I think what she's trying to do is basically screen pro-prosecution type jurors and make sure they stay on as much as she can, and then keep the ones that could be considered pro-defense, keep those, get those kicked off. Ashley's saying, did I hear about the Sallyport inverted camera still being up and active for the audit guys? Breenan has said it had been removed and replaced several weeks ago in the court. Yeah, I just don't put a lot of stock in what these audit guys are saying. Maybe they got it wrong. Maybe Brendan got it wrong, but it's just not a system you can trust. These audit guys poo-pooed everything, and what Brennan says, I wouldn't trust a single thing Brennan says. I wouldn't. Stay pause. How do we watch this and be gaslit for weeks and not get mad? It's infuriating. Yeah, just do what you can. Do what you can to support the defense here. Let's see. I don't know how to. I'm trying to present Anna Jaski's question. It's not showing up. You're asking, do I think the defense will have a fair shake during the cross-examination? I am concerned Brennan will be relentless with objections and a high probability Cannone will be sustained. Yeah, I have the exact same concern, and it's just going to be ugly. So thank you for your support, but I just had the exact same concern, and the defense needed to just really buckle down and take on this judge and build a record and talk about what she's doing on the record, that she is blatantly siding with the prosecution in her rulings. You need to come out and say that. It's not even looking fair, Your Honor, and be all respectful, treat her with dignity and respect at all times, but state for the record exactly what she's doing to cut him off. Thanks, Laura J. Yeah, it's hard not to get high anxiety if you're like justice focused. If you can't sleep good knowing somebody's getting unfair shake through a justice system or wronged in any way, then yeah, this is a case that can be hard to live with. But like I say, that's why I want to do this show tonight, to talk about, hey, there's case law that supports what I've been saying. This is unconstitutional. She's been railroaded here, and it's going to be either the appellate judges in Massachusetts or a federal judge or two that's going to step in and do right by this case. I don't think the Supreme Court's going to take this case. I'll be really surprised. And if they do, I don't think they're going to grant any relief. Lindsay Taylor saying, please read previous super chats. I don't know what I'm doing wrong. Oh, here. I got a note saying loopholes to buffer religious, racial, gender. Yeah, I mean, think about one of the things that somebody like Brennan's going to be doing. He's going to be, what he's generally going to probably be trying to do is which you cannot. It's unconstitutional. But I think he's gonna probably be more likely to have. You're probably going to see most likely an all Caucasian jury here. I don't think you're going to have any racial minorities on there. Religious background should not really be a factor. I don't really see that ever coming up in trials. Gender, I think they got like last I'd heard they got a 50-50 split, 5 each. And so I just don't think there's any, I don't think there's any concern about that kind of the demographic backgrounds of the jurors here. That's going to be an issue. But I do think that the prosecution guys like Brennan, what I've seen before is they try to kick out any minority, but they have to have a basis that's race neutral if they're going to try to kick them off. But I just that's what I've seen before, and we'll see how this shakes out. But my prediction is I'll be surprised if there's anybody but that's non-Caucasian on the jury. Grave concerns. You're saying one of the best Lally quotes from 1.0 is there's no evidence of anything in this case, Your Honor. Yeah, that no evidence. That's quoted by Brennan a lot too, which is completely not the case, as we know. F.R. Smith, Judge Cannone is not excluding them, but she wants to do is have them show up the day before, and then she wants to have them go through a rigorous voir dire, which means basically she wants the prosecution to rake them over their coals to see if there's something that they maybe had in communication with that they weren't being forthcoming with, or to catch the defense team from doing something that they didn't turn over, some kind of email or communication timeline. So the prosecution is gunning for some kind of technicality to keep off these ARCA witnesses, and the judge is allowing them to do that through a hearing and through voir dire, which is absolutely so pro prosecution. It's unbelievable. She's just looking at for something to exclude these witnesses, but um, we'll see. So they've not been excluded yet, but she's looking for a way to gun them down. That's what it looks like very clearly to me. You guys, I see some comments about super chats. I'm not really familiar with super chats. Originally, I had those starting out, and then I didn't have them for gosh, probably a year and a half. I just turned them back on because I read that this is a, if I'm preventing YouTube from also getting a cut on it, then they don't promote the channel as much. So I just went ahead and turned it on, but I'm never going to ask for money. Okay, so just making that clear. I'm not asking for money, but thank you for you guys that support it, like Marine, who's saying, Marines 100, who's saying, never lose hope, justice shall prevail, keep strong and believe. Thank you for your support. I don't understand how people that are anti-Karen Reed are not disgusted with the behavior of the law enforcement, the behavior of the prosecution, and how biased the judge is. I just, we should all be in unison on that. Okay. It's not an issue of these kind of issues are denial of fair trial. And look at it this way: if you're anti-Karen Reed, wouldn't that bother you if all this reversible errors was being developed? Wouldn't you want a conviction to stick? Well, is it more about some other thing than justice? All right, I'm a little bit behind her. I'm up to 808. Grave concerns. I have to plan to watch Hank on mute. Yeah, that's like our North Carolina retired patrol trooper definitely he said he's going to do the same kind of thing. Yeah, that's maybe the only way to stomach it. Chloe's mom is saying Brendan said the cameras at Sally Port have been replaced, but Canton Audit says they're still there and they hold 800 days of video. Yeah. The audit had more time, and they were there longer than Brendan would have been around there, I assume. So maybe they're correct and Brendan's wrong. I don't really, like I said, I don't trust anything he says. Not a thing. Brains on Hunter, you're saying stress causing watching and hearing objections, sustained cringe world. Yeah, I mean, it gets my blood pressure boiling. I cannot stand it. I cannot stand watching these. And I thought Lally was bad with all his objections. I think this is going to be like that's going to be like a walk in the park compared to this Brennan guy. But you know what? As ugly as it is, it's going to be on full display. It's going to be recorded for people to see for the rest of these people's lives. So if they don't act, if they don't act like they care about the Constitution, then it needs to be seen and heard how bad it can get for folks. Thank you, Doc Discussion. You're saying congratulations on your marriage and new home. Appreciate that. Listen, I appreciate you. I can't, for some reason, not letting me post chats, super chats. Matt is asking, so what do I think happened to John O'Keefe that night? You know what? Something other than what the prosecution is making out. Okay, that's what I'm convinced of. The prosecution's botched evidence collection, their failure to search the house of the Alberts, all the suspicious behavior of the Alberts regarding the butt dials, the deleted text messages, all the the time and effort it takes to get their story straight, the text message saying not to tell anybody that make sure don't tell the cops that John was ever in the house. I mean, why would they need to say that if that hadn't happened? So there was definitely not a vehicle strike. It looks like a dog bite and some other kind of event happened where there's uh, a fight, and dogs do intervene in a lot of fights between humans. So that's what it looks like from most people's perspective. I think that's what the jury's going to come out and conclude, and so that would mean Karen is not guilty of this. I think even if you look at the actual alibi that Karen has, that she was leaving the street there at 34 Fairview at around 12:29, 12:30 a.m. And we know she was confirmed to be at John O'Keefe's house at 12:36. And there was too much of people transiting the front yard area there between 12:21 when her and John got there with this other pickup that pulled in right behind him. So there's something else that's not adding up. I don't think you need to come up with names for the defense to do this third party culprit thing. It's I would just say something else, like I'm saying now tonight, something else happened. He got beat up. It looks like a dog attacked him, or he's, maybe he slipped and fell, hit his head on something. You don't have to come up with the theory. If I was a defense, I won't want to be bound to have the jury believe it's just this one alternative theory or nothing else. It's like anything could possibly happen other than what the prosecution's saying. And maybe he slipped and fell, maybe he's going behind the backyard and was going to go to the bathroom there, and the dog started attacking him. Maybe he started running, his head on the fire hydrant or something to get out of there. We just don't know. There's just too many things that are unknown, and they failed to preserve the crime scene properly. I do believe he was he was attacked by something other than just an animal and a dog. I believe that was the case. I don't think it was a fire hydrant or hitting his head on a curb or anything like that. So, but this theory that the prosecution has that Karen had done it, it's just not making any sense. And if it doesn't make sense, there's reasonable doubt. Avid Events saying, can the defense file a motion to reconsider Easter between prosecution and defense cases? It was Andrew Burkhart's suggestion. I would do that. I mean, I would just keep firing away. I'd consider also doing a writ. Maybe you could do a writ of mandamus up to a higher appellate court to allow this kind of instruction to happen. It's sort of a rare thing file, but it's something that if a judge is abusing her discretion and it's not otherwise right for appeal, sometime that's done. But what do you got to lose by asking a reconsideration? And if you wait till after the folks like Proctor and other law enforcement folks that you want to attack on cross-examination for botching the crime scene uh, collection, then you could actually cite what they're saying and how your cross-examination they denied it, and then why you need Easter to be able to be an expert to rebut them. So you need expert to battle it out, not expert in defense cross-examination. That's an unfair fight in many respects, just like that federal decision I said. So even no matter how good a job you could rake a government expert over the coals, it's not the same effect as then having um, your own defense expert to go head to head with them. And so I can just tell you as a trial attorney, no matter what side I'm on, I'm always looking for experts. That's one of the main things I'm thinking. How can I be creative and have an expert testify to something? And anytime I have used an expert, it's like a guaranteed win. So that's how important it is. Sixteen insane. You're saying if there's ever an appeal, who would judge the appeal? Well, they have an initial appellate court higher court of appeals, and then their Supreme Court is not called the Supreme Court in Massachusetts. Called something else, which some other states in the Northeast they do it that way. The highest court, like the U.S. Supreme Court, is the highest court, so you have Supreme in the title of the court. There in Massachusetts, not the same way, but it could go through the two appellate levels there at the state court level, and then it would go to habeas petitions in federal court, and that could work their way up from the trial level to the First Circuit Court of Appeals, which is federal, all the way up to the U.S. Supreme Court again. If the Supreme Court elects to have the case heard, very small percent of cases are heard at the Supreme Court, like less than 1%. Clayton John is asking, wonder if a visual display of what it takes to bust that tail light at demonstration. The judge isn't going to allow anything like that, but expert testimony, sort of like ARCA did that kind of thing. They didn't have visual, but they described it. But if they had video, stuff like that, yeah, that could be helpful. But with this judge, especially if it helps Karen, it's not going to be admitted into evidence. Dogs discussion, it's I heard it was like 50-50 right now, but it doesn't have to be. It could be any combination. It could be 1 and 11 or the other way around. There's no set formula. It's just a matter of you cannot exclude people based on their gender or race. I'm trying to catch up here. I'm way behind. You guys got a lot of good comments here and questions. Leslie's vocabulary. Can the defense ask the medical examiner about Proctor pressuring her to change the manner of death? That's something that should be admitted, but with this judge, you're probably not going to get that introduced into evidence. Bobby's trapper keeper saying, yes, she has her whole foot on the scale. Jennifer Rank is saying, basically, the judge did not want an expert on police procedures. Why isn't the jury allowed to be the official finders of fact? Yeah, a lot of her rulings, she's cutting out the jury from being the true fact finders, and she's reaching back to the first trial, and it's just, I just never seen it like it. This judge is really bizarre. Violent Lilac, you're saying the audit guys really screwed it up, 200,000 down the drain. Well, it looks like more of a community outreach type of audit than anything, and the serious constitutional effects of what was done on this case, and also the Birchmore case, just it wasn't even highlighted. So not credible in my opinion at all. Lindsay Tyler, you're saying so much for Hank's claim that his whole intention of taking this case was to ensure Karen gets a fair trial. I'd never heard that before. But him and his fair trial talk, I just don't buy it. Oh, Carolyn Dykeman, you're saying other judges from Massachusetts thinks Bev is being fair for both the prosecuting and defense. So I think even appeal will be tough. Keep in mind, if you're talking about a lawyer there in that area, they're probably going to say that because they got to practice in front of her at some point, or think they might have to. So they're not going to have an opinion that is really truly neutral. And who knows if they even watch it. Sam is saying if the feds are still investigating anyone they decide to make charges, when would you expect them to take action? What would that action, if any, look like? I don't want to really speculate on it. I would say they're going to wait until this trial's over with, and I just maybe there'd be some kind of racketeering charge or civil rights. I think civil rights against Proctor would be a good thing. Other than Proctor, I don't know what you have for proof, what they're doing for discovery. But civil rights and RICO kind of statute, racketeering is what the RICO statute's about. Basically, organized type crime. Lisa Byrne, I totally agree that the judge is not going to make this case easy at all. Or let's see. Sarah Clancy, I think the Crosby ruling and the Dr. Russell ruling is really insane for a lot of people. Yeah, it just really shows her double standards and how she comes to those decisions. Admissibility experts. Teacup, how do you deal with frustration, lack of justice? I hate it, but can't look away. I mean, praying for justice. If you want to support the defense cause there, that's something you could do as well, if in the affirmative, to deal with your frustration. Coming on, making comments, I think help. The more public coverage there is of this case, I think the better it is for the defense. Grace is saying, I feel the same way, and I appreciate everyone trying to remain positive. Yeah, we have to remain positive. There's going to be some rough days ahead. Kendra M is saying, there's so many appealable issues. I can imagine if that of KR is ever found guilty, it'll be overturned. That's what I'm banking on. I just don't see that ever happening, though. It should be convicted. But since we can't see the jury process. Lindsay Tyler, have I ever seen a prosecutor not call the medical examiner for a murder trial, instead shot for a different doctor who say what you want to speak for the medical examiner? How's that even legal? Yeah, that's how desperate they are. That's how desperate they are. They're form shopping, in essence, for an expert. And I saw some kind of discovery request where they want to know who the prosecution has talked to. That's what I recall seeing, and that's something I'd been thinking about. It's like when they're doing this, calling around the country to see what experts they can find. I guarantee a lot of them are telling them no, and they're maybe giving the file and say, "Well, maybe I'll look at it. Let me get back to you." And then you look at the file and go, "No, no, we can't help you because it looks like this wasn't a motor vehicle strike." So is that being turned over to the defense? I don't think so. And that's something that the defense needs to definitely be pursuing. The prosecution, I think, has a lot of people they reached out to trying to find. Maybe 1 out of 50 is what they had to go through before they find the one that they're going to call the witness. Grave concerns. Yeah, Lally was just spraying and praying objections would hoping he get some sustained. Yeah, I mean he was on a roll. Yeah, he didn't have to have a reason either. So he was a junior lawyer. So isn't that great for junior lawyers? Just if it sounds like it's hurting your case, just object. And with the judge like Judge Cannone, you got a 95% success rate. Larissa Harris, is so evident that pulling teeth with all the McDalberts on the stand. Are you talking about the McCabe's and the Alberts? I think by saying McAlberts, people that have nothing high don't behave like them. Higgins as well. Yeah, that's what I've been saying. They're acting highly suspicious. highly suspicious. Trial gazer, you're saying the Bryans were originally thinking about blaming it on Lucky the snowplow driver. It's Jen's idea to blame it on Karen. That's what I've seen other people saying, and that might be something that defense uses in their argument. Swampy, you're saying the killer of O'Keefe will never be discovered short of a confession. Canton PD did not investigate this crime, ensuring the killer would get away. They blame Reed. A conspiracy we'll never know. Somewhere down the line, I got to believe that the truth is going to come out. John Cuncho, you're saying as a lawyer, how do you preserve the court record for appeal when the judge upholds objections without hearing the cause or hearing them at sidebars? I think you're allowed to plug it in whatever your objection was after the fact in the appellate record. That's the only way I know that you could do that. You don't have to state the grounds, but if they were ruling against you, I would call a sidebar every time. If the judge says you're not allowed to come up for any sidebars for that, then I would I don't know what it would come to that point, but you're basically being muzzled in the courtroom, and that's not right. Yeah, that's Leslie's working herself, so I was able to jump on here and cover this tonight. Jennifer Rank, there are so many logical theories that involve the Elbers and Higgins. No theories that logically supports the state theory. That's a good way of saying it. Chloe's mom, thank you. I know you're not doing this for the money. I appreciate your wisdom and insight. There has to be a better way to keep the innocent out of jail. Appeals take years. How do we change other than voting? Oh boy, corrupt type of communities are really hard to eradicate. But if this kind of case with Karen Reed doesn't change that area up there, then not a whole lot will. That's all I can say. If this is not a wake up call for that area, I mean, I see comments, people saying they live in the area, they want to move, they're disgusted with the way people are treated there. It's so corrupt. Susan Trelease, if Judge Cannone succeeded in excluding ARCO, there would still need to be some reliable accident expert on this case because the Commonwealth is claiming that Karen's car hit John. Yeah, they do need an expert, but the thing is, they're not going to find another expert. It's either ARCA or they're not going to be able to substitute that. So there's all these discovery notices and whatnot. So they're not going to have another expert that I know of that's a backup in place of ARCA. All right, just jumping down here. I'm at to 834. I'm still a bit behind. Federal affidavit, you're saying, does the defense have to suggest a different cause of death than that of the prosecution? So the cause of death, I mean, if they had their own medical examiner and they said, no, well, it was pretty much all the hypothermia, not any of the head wound, then that would be something that show that it's really not even a manslaughter. But they don't have to do anything. The defense doesn't have any burden here, and so I would say no. They don't have to suggest anything. If the prosecution has anything incorrect and they want to bring an expert to rebut it and refute it, then they can do that. But here, the medical examiner pretty much supported a lot of what they were saying, and the medical examiner never ruled it a homicide. So that was a huge win for the defense. Thanks, grave concerns. Mary Beth Palalanus, the botched investigation screams reasonable doubt. That alone is it right there. Ms. Jim Morrison saying the first trial they redacted the manner of death, but the door was open during the trial. Gambrell girl is asking, why can't Cannone be sanctioned for not filing case law if it goes up on appeal after conviction? They don't sanction judges for bad rulings like that unless there's some kind of direct corruption that they find. She's not going to be sanctioned for anything. That's just the way it works here in America. Sherlock Snoopy, can the defense in opening define the role of judge and prosecutor in defense and warn they were about to witness a biased trial and identify the types of biased actions, such as many objections, stuff like that? No. If you did that, you'd probably get shut down right away, especially by this judge. I wouldn't recommend that either. Let the jurors see that for themselves rather than predicting that's going to be the outcome. And but I would definitely talk about the number of objections by the prosecution. I would have done that in my closing before, because they had so many legitimate questions that were kept out by this judge. Malin is law is saying Jackson and Yannetti are both starting to push back on Cannone's ridiculous behavior. I hope so. They need to be more aggressive. I'll tell you that. They need to have street smarts on when they go after this prosecutor and the way he's putting a spin on so many things. All right, just going through. Let's see. Law and Lit 8027. Did I catch a few weeks ago when the judge was not happy about Brennan giving the file to on Proctor directly to the defense instead of going through her first? Wonder what you make of that. I did not see that, and it wouldn't. It's really shocking a judge would be concerned about that. But given this particular situation with this judge, I'm not surprised if that happened. Okay, RN is saying I want to believe in justice. I also watched the jury let Casey Anthony off. Yeah, that's a aberration from most of them that I've seen because in that case they went for first degree murder and took everything else off the table and they really forced it on the jury to not have any other alternatives and it's either murder one or something else and then they try to blame it on her dad and so therefore just that one issue that the prosecution was not ready for, so you had just a couple of really I blame it on the prosecution for not allowing second degree murder and just leaving it to first degree murder is what really caused that outcome, I would say. Fr Smith, I look forward to Ark of Ordar with the two experts looking at Brennan like as if he's has two heads with each of his misleading questions. Yeah, those guys are sharp. They're not going to be able to. He's not going to be able to trick them at all. RN is saying, "Hi, I'm Drew Carey. Welcome to Whose Court Is It Anyway, where the orders are made up and the motions don't matter. Well, at least the motions for the defense." Lally, the disgruntled paperweight, is saying there's 2,100 board certified neurosurgeons in Massachusetts. And they had to go all the way to Florida for this guy. That's interesting. Like I say, I think they called around a whole lot, shared the file with different docs, and they probably got some answers they didn't like to hear. So that should be turned over to the defense. Chloe's mom, I believe I already covered your question. I don't see what it is here now. Someone was glad to see Anetti upset with the judge. They need to be very aggressive, competent, forceful, and tenacious, and professional, of course. Ipsy saying nobody wants this case an excerpt for the Commonwealth. That's how they ended up with Crosby. And I don't know about him in his animal control days, but I know he was a cop. So was he part of the animal control as a law enforcement officer for 20 years? Rosemary Gallagher, you're saying, I believe this will come back to haunt the Commonwealth, just might backfire. KS40 is saying, I've driven in a blizzard and a 4x4. The most I could do is going 20 to 25 going forward, going backwards, maybe 5 to 10, not 24 miles an hour. 4x4 means four-wheel drive vehicle for those of you out of the States. May not know that. Rage of Dragons, what date is trial actually starting? One more week, do you think? I think within a week from tomorrow, roughly, give or take. Could take another week after that. It could be done even sooner than that. We just don't know, but it's moving along pretty fast, real fast. All right, I'm going to take a couple more questions and then go ahead and sign off for the night. Thank you for all your support for the cause here. You're saying here the audit acknowledges serious issues with the investigation. I think it's pro Karen. I don't think it's pro Karen at all. I think it's just they're stating the obvious, but they soft pedaled and talked about other stuff. None of the stuff was that big a deal. The magnitude of it was not addressed at all. Summer every day is asking if I think Judge Cannone, when she says I'll take an advice, it means I got to phone Morrissey. I think she is calling other people. She should not be calling Morrissey, but I think she's maybe talking to some other judges. But what judges are giving her this kind of advice, I have no idea. Are they really that bad up there? Okay, Ipsy, you're saying, talking about John O'Keefe, he was hypothermic, but his body temperature was 80 degrees. He had no frostbite. Officer John O'Keefe had not been in the snow 45 hours with no coat. If that's accurate, the 80 degrees, yeah, I totally agree with that. That right there shows it wasn't anything having to do with Karen. That should be highlighted big time. If that's accurate, the 80 degrees. I'd seen that before elsewhere in the last 24 hours. Now, any ruling, if that needs a written opinion, the judge is going to say, I'm taking under advisement. So that's a normal course for a judge to say that because they got to write up the opinion. So that doesn't necessarily mean they're reaching out to any other judge. Grave concerns, you're saying also the lack of frostbite is such a telling sign Karen didn't hit him. Jennifer Rank, is criminal prosecution of by a proctor by the feds possible? This would protect Karen from these bad actors. They're not going to do it during this trial, maybe after, but it's only a misdemeanor for something like the situation involving Karen Reed, but remains to be seen what they do. I'm not very optimistic about the feds stepping in and doing something on this case. I was surprised they did what they've done, but actually going after folks with some type of anti-corruption type charge, I just don't see that happening. Yeah, despite I don't think they've found enough evidence of anything to charge anybody other than what Proctor's done. Just jump through any more. One last question. All right, this will be Andy School. You're asking, can Jackson ask Arca with emphasis, wide eyes, all but wink, wink, nudge, nudge. Dr. Wolf, are you also employed by federal government agencies that have acronyms without it being overruled by an objection? I mean, that's part of this whole thing about they can't say that they're part of they weren't hired by the U.S. Attorney's Office to look at this exact case. I think is it's just such a denial of due process for Karen. The jury wants to know, how did they become involved in this case? Who hired them? And so look at all this that Brendan is trying to Hayes trying to make out of the fact that they had some contact that he wasn't involved in directly. Part of that, the ARCA contact with the defense team, he thinks that's very suspicious. He thinks he needs to know every little detail, what they communicated with and whatnot. He's already seen their testimony at trial. So what other testimony outside of that is really relevant? These guys are totally credible. They're not biased. So I think that the saying what their background is, the types of clientele they have, establishes your credibility. So, if you're a lawyer and you do corporate law at a private firm and you're a name partner firm, if you can tell, if you become a witness in a case, and you can say you're a lawyer for the top 10 largest corporations in the world, you have a different clout than to say you're just a guy hanging out a shingle and you don't have any big name clients. You just have some mom and pop shops on off the town square as your clients. So why can't you say who their clientels are? Why can't you say they were hired by you? How did they got involved in this case? It's always critical to know for the jury, how did this expert come to be hired on this case? So we know the reason why, because it gives them instant credibility, and it's nothing that the prosecution has any counterweight to. So that's why they don't want it in, because they know it'd be a slam dunk, open and shut case. Jury wouldn't even be arguing for several days. They'd have made up their minds. If that would have came out in trial one, jury would have been deciding the whole thing probably within a day, even with that cop on that was there as a foreman. All right, with that, I'm going to go ahead and sign off. I'll do more coverage of this this coming week. So thanks for your support of Justice Matters, and have a safe, good week. We'll see you down the road here soon. Take care. Good night.